Morning, everybody. My name is Jay Sherman. We're talking today about workplace investigations. Let me tell you what we're going to be talking about today. We're going to talk about some common workplace issues, and certain things may not need to be investigated. So the question is, why do we investigate certain things? And then when to investigate, how to investigate, and notifying the complainant and the respondent. So the complainant is the person who brings the matter to the company's attention, and the respondent is the person who's been accused of something. And I'll just use that terminology throughout. So some common workplace issues that I'm sure have come up in all of your organizations are sexual harassment, discrimination, and retaliation. Raise your hand if any of you have had any of those situations in your organization. Okay, it's unanimous, or almost unanimous. And that's Bart Simpson. He didn't do it. So I'm going to go through 3 scenarios, and we're actually going to use this first one as part of our presentation today. But I want to go through 3 of them because I want to talk about the types of situations that can come up, just to give you an example of the kinds of things that might require investigation. So in the first example, Jim and Joan are inside sales persons who regularly discuss their sexual exploits in graphic detail in the company lunchroom. Ian, who works in finance, overhears the graphic conversations and is offended by them. Ian tells the VP of Finance about it. The VP of Finance doesn't do anything to prevent it or doesn't stop it in any way. And the offensive comments continue for 6 more months. And finally, Ian gets fed up and notifies HR. So this is just a scenario, and we're going to be talking about it again later on. But let me give you another scenario. Discrimination. There are 4 employees who are customer service representatives, 2 Hispanics, 1 black, and 1 white. The department head promotes the white employee to a supervisor. The other 3 employees complain to HR that the decision was based on race, not on merit. So we don't know from this what the real motivation was, but since the complaint is made by the 3 employees, the company will need to investigate. And here's an example of retaliation. Rhonda, who works in IT, notices several accounting clerks working through their lunch breaks on multiple occasions. Rhonda reports the matter to her VP, who happens to be friends with the accounting manager. 1 week later, the company tells Rhonda there is not enough work to justify keeping her employed and that she will be laid off. Rhonda complains to HR. So the issue here is, was she being retaliated against for reporting the meal period violation? Okay, so those are examples of things that may come up, and the next question is, why do an investigation at all? In other words, what's the legal reason why a company might consider doing an investigation? And the answer is found in the Fair Employment and Housing Act. And the Fair Employment and Housing Act does not specifically state you have to do an investigation. But what it does say is that the employer must take all reasonable steps to prevent discrimination and harassment from occurring. So that's been interpreted by the courts as meaning that organizations need to investigate so they can find out if the alleged misconduct has actually occurred, and then to put a stop to it. So that's why we investigate, because of the Fair Employment and Housing Act. There's another reason, and that is to reduce legal liability. Between 1980 and 2015, the number of percentage of court cases that are being filed in our civil courts, which would be the Superior Court of Santa Barbara County or other counties, has gone up from roughly 5% to 22%. So just in 35 years, it's more than quadrupled. So there's many, many more employment law cases alleging violations of FEHA, alleging wage and hour violations, and related matters. There's many, many more of those today than there were 35 years ago. And companies, the only way they can really protect themselves is by being very diligent in monitoring what's happening in the workplace and trying to prevent any harassment, discrimination, or retaliation. So there's really three things employers can do to reduce their exposure to lawsuits by employees. One is they can promptly investigate, and they can take corrective action if it's warranted. Two, they can train their managers and supervisors about wage and hour rules, meal period, rest period, overtime rules, and recognizing and avoiding harassment, discrimination, and retaliation. So those are the two things. I said there were three. That was actually two. And the reason there's a third bullet point is, in many cases, problems in the workplace that lead to lawsuits, in many cases, are caused by supervisors or managers who just are ignorant of what the laws are and what is required. So we'll just there's a few more people coming in, we'll let them get seated. And then I'm going to show you a cartoon about this. So the point here is, you need to train your managers and supervisors in these various issues, wage and hour issues, discrimination, harassment, and retaliation issues, so they're aware of them and they can be on the lookout for them. So here's the cartoon I promised. It says, there's a boss talking to a bull, and he says, "I'm disappointed. If anyone should have seen the red flags, it's you." Okay, so now we're going to move on to when to investigate. For those of you who receive employee complaints, I'm sure you'll agree that many days employees come in and will complain about different things. They'll complain about their supervisor. They'll complain about maybe the people next to them in the next workstation next to them are distracting them. They'll complain about many things. Not every complaint merits an investigation. So you have to use some judgment as to when to investigate, when not to investigate. From my experience in HR, I found that sometimes people come in because their manager or supervisor isn't listening to them about something, and they just want somebody to talk to. They want to vent. Has that happened to any of you? Okay. And sometimes the only thing you really need to do is just to listen. And a lot of times people feel better after they've complained. So maybe you can do that in some situations, but in other situations you actually have to investigate. So we know we're going to investigate harassment, discrimination, retaliation. We know we're going to discriminate wage and hour violations. And here's one: threatening or intimidating conduct. That needs to be investigated. Most organizations have a zero tolerance policy for workplace violence or threats. but also threats or intimidating behavior could lead to a claim of harassment. So that needs to be investigated. And there may be policies in your company that also have been violated that need to be investigated. So here are some common traps for the unwary. And some companies and organizations have gotten burned because they fell into these traps. So I want to just go over them with you. The employee comes in and talks to, let's say not HR, but let's say they talk to a supervisor, and they talk to the supervisor off the record or in confidence. If the employee goes on to tell about that they're being harassed by somebody, that person who received the complaint must investigate or must turn it over to HR to investigate. And so there really is no off-the-record comment. Sometimes the employee complains, and then as an HR person, you say, well, we're going to need to investigate, and the employee says, oh, well, you know, it's really not that big of a deal, and I don't want to get anybody in trouble. So again, if some of these important issues have been raised, the company has an obligation to investigate. And the third, this has actually happened in an organization that I worked. We had a vice president who was very, everybody liked her, and people used to go into her office and just vent to her. And very often about people that weren't in her department or not even in the employees department, just things that they had seen. And she was just being kind and just listened, but she was a vice president. And there was one situation where an employee told her about a manager who would go into management meetings and start making not racial, sometimes racial comments, but very often like offensive sexual comments. And the vice president never investigated it because she thought people were just coming in to talk to her, just to help them feel better. But anybody in management, from supervisor on up, has to act when they find out about these types of harassment claims. Okay, how to investigate. So I'm going to direct your attention back to that scenario that we had about the sexual harassment. So, and I'm going to ask for this is going to be an audience participation question. So as we discussed before, Jim and Joan like to share their sexual exploits in the company lunchroom. Ian overhears these things, tells his manager doesn't do anything, and the offensive comments continue, and Ian gets fed up and he notifies HR. So assuming that one of you have just been notified by Ian of this situation, I'm going to ask you, and then we'll go over it, I'm going to ask you, what would you do? Like, what would be the first thing you'd do? And we have a microphone here, so if you tell me your question, I'm going to repeat it for the microphone. Okay, any volunteers? What would be the first thing you would do?
I would thank Ian for telling me about it. I would tell Ian that I would get right on it, and I would ask him for his patience and let him know I'd get back to him as quickly as possible, and that because there was now an investigation going on, to please not to talk to other people about it. Then I'd go right to the VP of Finance and say, what the heck?
So, yeah, that is a good start. The first thing you want to do is you want to gather facts from the complaining party as much as you can. Now, in this case,
Yeah.
what we don't know, because the scenario doesn't tell us, what we don't know is whether Ian has ever sent an email to the VP of Finance saying, you know, I'm really offended by these comments. We don't know. So we probably would want to ask Ian that. Do you have any emails? Do you have any text messages? In some organizations, employees text message each other. They text message their managers in some cases. So he may have text messages. He may have also taken some notes at some point. So you want to get as much information from the complaining party as you can. So that's really the first step. And the next step is and I find this helpful myself, being able to take facts that an employee has just presented to you and figuring out, okay, if I'm going to investigate, what are the allegations that I'm going to investigate? So it's sometimes very helpful to break down what the person's saying, because we have a few things going on here. We have conversations in a lunchroom. They were going on for a period of time. Were they truly offensive? Under California and federal law, for sexual harassment to take place, or hostile work environment sexual harassment to take place, it has to be conduct that was unwelcome and of a sexual nature, and that happened. Jim and Joe made sexual comments that Ian overheard. 2, the sexual comments that Ian overheard continued for several months. So we want to make sure there was pervasive. Pervasive really means that it went on for a period of time. And 3, the comments that he overheard were inappropriate for the workplace and offended him, so that they were of a sexual nature and that a reasonable person and Ian were offended by them. So it's helpful sometimes to break it down, because when somebody comes in complaining, sometimes they're emotional, sometimes they just give you a whole bunch of stuff. They kind of give you an explosion of information, and it's helpful to just break it down. And that's an important step to do. I'm doing an investigation now where there's allegations of by an employee against the general manager of improper conduct, counter allegations by the general manager against that employee of improper conduct, allegations by the employee of gender discrimination, and lots of other things, bullying. So it's really helpful to kind of break it down into its component parts. And by the way, on the handouts you have these steps. There's 12 steps that I've included. They're on your handouts. And as we go through these, I encourage you to ask questions. I intentionally limited the number of slides so there would be time for questions. If we can answer some at the end, but as we go through the steps, if you have a question, it's perfectly okay to ask it during the presentation. Okay, so step 4, determine who the witnesses are. So as this one of our attendees said earlier, you want to talk to the VP of Finance. That's certainly a witness. You might also want to ask Ian, were there other people in the lunchroom or other people in your area that may have heard these comments? So you want to determine who the witnesses are, and sometimes you'll end up finding, after you talk to the respondents, sometimes you'll find there's even more witnesses. But you want to start creating a witness list. And each time you interview a witness, you want to ask them if they have emails, documents, or text messages. Because if you get an email, it can be really valuable for different reasons. Okay, I'm going to throw this out. There's 2 important reasons why an email or a text message can be really valuable. Anybody want to guess? Okay, yes?
The date and the time.
The date and the time, yes. Yeah, the great thing about emails is that they capture the date and the time. Okay, that's one reason. Any other reason why an email might be valuable? Yes?
Evidence.
Evidence in written form. Yeah, I had a situation in this case I was telling you about where the general manager was accused of threatening people's jobs. And he denied it. He says, oh no, I never threatened their jobs. Well, one of the employees who complained gave me an email that she had sent to her supervisor after the general manager said something to her. She wrote an email to her supervisor saying what occurred. So that happened. We know what day it happened. We know what time it happened. And we know that it happened. She sent the email right after it happened. So it's pretty convincing evidence. So when later on, when you have to weigh who's telling the truth, that email can be a big factor. Any of you work in the public sector? Okay, a couple of you. So you know that in the public sector, before you can interview a respondent, you have to give them reasonable notice. And if they're a union employee, they have the right to bring their union rep with them. Now that's kind of, those two things are unique to the public sector. In the private sector, there's no actual legal requirement as to how much notice you give somebody before you interview them. And sometimes it's advantageous not to give them a lot of notice. Because if you give them too much notice, maybe they'll start making some things up, possibly. So it's always a case-by-case decision on that. There's a question, yes?
Jay, is there any point in asking Ian who else he told?
Absolutely. Absolutely. It's a very good point. So even if 60% of the evidence says it happened and 40% said it didn't happen, you can still make a finding. And one of the problems that some HR people have had, and maybe just because they haven't been informed or haven't been trained, it's okay to make a finding. You don't have to be 100% sure. You just have to be, you have to have enough evidence to say it's more likely than not, and you need to be able to explain why you came to that conclusion. We talked about this a little bit, about the assessing witness credibility. And one of the things you want to look for is you want to look for bias. I did an investigation where there were several employees who worked in a warehouse. And they were all men except for one. And the female employee complained that one of the male employees was coming on to her and saying things to her about his sexual conquests and things like that. And he was getting into great detail. Well, I interviewed the other 4 male employees to see if they'd ever overheard any of those conversations. And all 4 of them said, never. This guy, who was the respondent, never talks like that. It's not his personality to talk like that. He's always very polite and very appropriate, etc. Well, then I found out that the respondent and these other 4 guys socialize after work. They socialize on the weekends. I think one of them was the cousin of the respondent. And so even though there was one woman who complained, and there were the respondent and 4 others who denied what she said, I determined that those 4 guys were biased. Now, there was some other circumstances that I was able to use to reach a finding, but knowing that there's a bias is really important to uncover that. Sometimes bias goes the other way. Sometimes somebody will say something bad about a respondent when it really didn't happen, because maybe they don't like the respondent. Sometimes the person is friends with the complainant. And so they want to get the respondent in trouble because they want to help their friend. Because even though you tell people, you know, it's confidential, they all talk. And there are some limitations. There's a National Labor Relations Board decision from a couple years ago called the Banner decision. And under the Banner case, there's some limitations on confidentiality in terms of you can, in some cases you can say, don't discuss this with anybody, but in other cases you can't. And that's really a legal determination. If there's a high risk that if people share information, the investigation will be tainted, then you can do that. You can ask them, you can admonish them to keep it confidential. And then going back to credibility, does the witness have a motive to lie? Well, if the witness, if the respondent gets fired and this witness is next in line to be promoted when he's fired, maybe this witness has a motive to lie. So you want to look at that as well. But we're going to talk about notifying the complainant and the respondent after the investigation. But before we do that, I wanted to just cover one point that I think is important. Whenever you start interviewing the witnesses, including the complainant, eyewitnesses, the respondent, it's always a good idea to tell them at the very beginning when you do the interview that our organization has a policy against retaliation for people who participate in investigations. So that means we cannot retaliate against you because you participated, and you cannot retaliate against anybody else because they participated. And the reason that part 2 is important is often you're interviewing a manager, and the last thing you want to happen is you don't want that manager going back to their employee who complained, and the manager start picking on the employee. So it's always a good idea to explain retaliation before you get into the witness interviews. I also always tell witnesses, if you need a break at any time, you can take a break. Because even though the company has a policy that says you must participate, you don't want to make it seem like you lock them into a room. So I always say that. And I also ask them, you know, is there any medication or health reason today that you can't give an accurate statement? And they almost always will say, no, everything's fine, I'm feeling fine. So if you cover those up front, then I usually start going into my questioning after that. Okay, so now you've done the investigation, and now you need to get back to the complainant and the respondent to let them know what you found. So with the complainant, you know, since they were the one that came to HR in the first place, I always think it's a good idea to meet with the complainant in person and say, we've done an investigation and this is what we found. Now, oftentimes complainants are emotional, and I'm not saying that's anything wrong with that, because if they've been harassed or discriminated against, they have good reason to be emotional. Sometimes it didn't happen though. Sometimes they misunderstood, or there were other things going on. But it's always a good idea, particularly because they came to HR in person, it's always a good idea, I think, to meet with them in person. Use that same personal touch that you used when you interviewed them to tell them what the investigation found. But then I will confirm it in an email. I think it's very important that there's a paper trail so that it can be traced what exactly happened. Now, with notifying the respondent, I would say this: say as little as possible. even if the evidence didn't really support the complaint, and your finding is that the allegations are not sustained, and sustained, I know it's a legal term, and you know, those of you who watch courtroom dramas on TV, you'll see objection sustained, etc. But I think it's a really good word for what you find in an investigation. Because the way it starts off with an allegation. This happened to me. That's the allegation. And if there's enough evidence, you'll say, yes, this happened. But if it didn't happen, the thing to say is the allegation is not sustained. That doesn't mean, you know, it's 100% sure it never happened. It just means it's not sustained. Which means that if another person complains about the same respondent 2 months from now, you might get more evidence. So it doesn't mean the respondent is exonerated, okay? It's very rare that a respondent is exonerated, where there's just a mountain of evidence showing that the complainant was completely wrong. So I like to say that the allegation was not sustained. We've concluded our investigation, the allegation was not sustained. And just leave it at that. And if the respondent wants to talk to you, I still wouldn't say very much. I would just say, you know, we didn't find the evidence to support the allegation, and there's really nothing else I can tell you. Now, if the allegation is sustained, then the company's probably going to take some sort of disciplinary action, either a write-up, last chance agreement, termination, depending upon what it was. And then you want to give a little bit of the findings. So if, like I said, I broke down the findings in that one example into 3 allegations and 3 findings, I would give them what the 3 allegations were and what the 3 findings were. I would do that. In terms of weighing all the evidence and all that, I wouldn't necessarily tell that to the respondent. If later on, let's say you terminate and there's a lawsuit, they're probably going to get all that information anyway, but at this stage, there's no particular reason to go into detail. Just say, yes, we did the investigation. We found that you and Joan were talking about sexual items in the lunchroom in graphic detail. We found out you did this for a long time, and we found out that that Ian and possibly other employees were offended by it, and that it violated our company policy because it was the types of things you talked about were inappropriate for the workplace. So that's what you want to say, and then impose whatever discipline you're going to impose. Okay, so we have about 6 minutes to go, and we've had a few questions, but we're ready for some more. Yes?
So what if the complainant is upset that the person's not being terminated? Like, how much detail do you give to say, here's why we're, discipline action, but at the same time you don't want to tell them too much? Like, how do you handle that part?
Well, you know, when the complainant comes forward, in order to answer your question, like what to do when the complainant is upset because the respondent's not being terminated, let me give an example which is a little bit off your point, but I think it will illustrate your point. Suppose the complainant decided after the complaint was made that to leave the company. Maybe not even for this reason. Maybe their family was moving away. So you get the complaint, and the next day, the complainant doesn't work there anymore. Do you still investigate? How many say yes? How many say no? Okay, yes is correct. You still investigate. So the reason I bring this up is, once the organization learns about the misconduct or the alleged misconduct, it has a duty to proceed. So it's not really personal to the complainant anymore. It's about, goes back to FEHA, to prevent future occurrences of harassment or discrimination from occurring, which is what the statute says. So you're doing this as an organization, you're doing the investigation. It's not personal to the complainant anymore. The organization is going to do what's right under the law. So if the complainant's upset because the respondent's not being terminated, then they're entitled to be upset. It's their human reaction, and it's understandable. But if you've done a very thorough investigation and you've talked to all the people and you've read all the documents, and the evidence doesn't support termination, maybe it supports some sort of discipline but not termination, that's the organization's decision. It's not the complainant's decision. So I would say you just have to explain that to the complainant. Okay, we have a couple more minutes. I know there's at least one more question. Okay, no other questions?
I have one.
Yes.
Tell us just a little bit about how you establish rapport. How do you go about it?
Okay. Well, this is more of an art than a science, and this is where my HR background comes in. And the question for the microphone was, how do I establish rapport? The one thing I learned in human resources is most people come to HR to complain because they're not being heard. That seems, supervisors are busy, managers are busy, everybody's under pressure to get work done. And so people come to HR because they want to be heard. And that's the philosophy I use when I interview people. I find that people want to be heard, and so I make them feel relaxed. I'll talk about something like if they say, "Oh, I just got back from vacation," I'll say, "Oh, where'd you go? And what'd you do? How was it?" But even when they're just talking about work stuff, very often they want to talk. And my interviews tend to be usually an hour. Very rarely do I have an interview that's under an hour. And some people might say that's a lot of time, but it's really the only way that I know to get people to really open up. So to make them feel really comfortable, and if they tell you something and say, "Oh, that's interesting, tell me more." So I just try to be a good human being. And I think you'll get a better interview that way. Any more questions? Yes.
Training is going on. People, HR is getting trained. And there's still more and more sexual harassment claims. You hear it in the media. Why do you think that is? Is the training not helping? They're not listening?
I think about that a lot, and I actually do the AB 1825 training myself, so I think about that a lot. I think that's just one area where people have trouble controlling their impulses, and if something's not going well in their personal life, it'll come out in the workplace. So I think training helps. I think training helps the supervisors to know to report it. That's where it helps. I'm not sure it's going to stop people from saying or doing inappropriate things, because it's part of our makeup. That's my lay opinion.
Media. You can't have experiential like they have and have people not think that that's just in our everyday life.
Right. We have.
So much of the media.
Right. There's a lot of media sexploitation, And if any of you watched the Emmys the other night, I mean, half the TV stars that come out, the women are wearing very low clothing, and but I just think it's just part of the human condition. So anyway, it's 12:30, everybody. I hope this was helpful.